In a moment that stunned political circles and legal commentators alike, Karoline Leavitt, the rising conservative firebrand, took center stage in a televised legal forum and delivered a scathing, meticulously reasoned critique that left Supreme Court Justices Amy Coney Barrett and John Roberts visibly shaken. The debate was intended to be a polite exchange on recent controversial rulings, but Leavitt came armed with constitutional citations, precedent-breaking analysis, and a tone of fierce determination. Her argument, that the court's recent decisions reflected judicial activism, not originalist interpretation, and she didn't hold back in calling out what she termed institutional betrayal. The confrontation began as a panel discussion on judicial philosophy, with Roberts and Barrett defending the majority's stance in a landmark decision. But Leavitt interrupted with precision, stating that their ruling had twisted the Constitution's intent. She challenged Roberts' view on judicial restraint, arguing that his version selectively applied restraint to appease political pressures rather than uphold principle. Turning to Barrett, she criticized the textual interpretations that, according to Leavitt, ignored the founders' deeper moral framework. "The Constitution is not a living document," she declared, "but neither is it a dead script you dissect with selective logic." What followed was a legal dissection unlike anything seen in a public debate setting. Leavitt cited the Federalist Papers, particularly number 78. To argue that the Supreme Court had veered from its role as the guardian of constitutional boundaries. She accused both justices of abandoning their originalist pledges and instead interpreting law based on political expediency. She specifically called out the court's recent ruling on federal regulatory powers, saying it trampled states' rights and individual liberties. Barrett attempted to counter with a legal precedent from the 1990s, but Leavitt was quick to dismantle it, referencing a more recent circuit court contradiction. Audience members, including legal scholars and former clerks, were visibly captivated. Some nodded in agreement, others whispered in disbelief at Leavitt's unflinching tone. What made her takedown so potent wasn't just the content, it was her confidence, her fluency in legal doctrine, and her refusal to be swayed by titles or robes. When Roberts tried to redirect the conversation toward judicial independence, Leavitt countered with a chilling critique. "Independence means integrity, not insulation. You're not above reproach because you wear the black robe. You're accountable to the Constitution and to the people." Barrett, clearly frustrated, raised the issue of stare decisis, respect for precedent, as a defense. But Leavitt pounced on it, citing examples where the court had overturned decades of precedent when it suited ideological goals. "You can't wield stare decisis like a shield when it's convenient and abandon it when it's not," she argued. Then turning to a major abortion-related case, she demonstrated inconsistencies in how precedent had been applied between social and economic issues. Her synthesis of constitutional clauses and case history left even seasoned jurists impressed. Legal analysts watching live called it a masterclass in disciplined confrontation. As the debate wore on, Roberts attempted to de-escalate, suggesting the court had to interpret laws within the limitations of what Congress provides. Leavitt wasn't having it. She brought up numerous cases where judicial activism had filled gaps Congress had deliberately left open. "Silence from Congress is not permission for the bench to legislate," she shot back. "You don't get to become lawmakers in robes." Her comment drew gasps from some viewers, but she backed it up with a timeline of rulings that had expanded regulatory agency power without legislative backing under the court's silent blessing. Social media erupted within minutes of the forum airing. Clips of Leavitt's exchange with Roberts and Barrett were shared widely, with hashtags like Leavitt Legal Clinic and Judicial Smackdown trending across platforms. Legal blogs posted transcripts while both conservative and liberal pundits weighed in. Some accused Leavitt of disrespecting the court. Others praised her for having the guts to call out what many saw as inconsistencies in modern jurisprudence. Even legal professors from Ivy League institutions expressed admiration for her clarity and sharp command of the Constitution, despite ideological differences. Back at the forum, Leavitt concluded with a blistering rebuke. This isn't about left or right. This is about fidelity to the text, to the structure, to the sovereignty of the people. If you forget that, you forget the essence of your oath. The room went silent. Neither Barrett nor Roberts responded immediately. Instead, the moderator swiftly ended the segment, thanking everyone for their spirited engagement. Behind the scenes, attendees described the justices as visibly rattled, though they maintained professional composure. It was clear that Leavitt had left a lasting impression not only on them, but on the broader legal community. Following the event, political commentators speculated whether Leavitt was positioning herself for higher office, or perhaps a legal role of national significance. Her team declined interviews, letting her performance speak for itself. Meanwhile, the Supreme Court released a carefully worded statement affirming its commitment to impartiality and respect for public discourse. Though unnamed, the statement was widely seen as a subtle response to the challenge posed by Leavitt. For many, this debate signaled a generational clash between institutional tradition and a new wave of constitutional purists unwilling to bow to established authority. As the dust settled, one thing became clear. Karoline Leavitt had reshaped public perception of how political figures can hold even the highest legal authorities accountable, using logic, precedent, and moral clarity. Whether one agreed with her or not, the sheer force of her argument could not be ignored. She had stood toe-to-toe with two of the most powerful legal minds in America and refused to back down. In doing so, she sparked a new national conversation on judicial accountability, constitutional fidelity, and the role of courage in legal debate. And in that moment, her star rose higher than ever before.